We have legal eagles to help your bookish adventure soar here on the BookFest, Fall 2022. I would like to welcome our panel of legal experts. They're going to help us. A lot of times as writers and people in the publishing world, it can be a little bit confusing, especially, oh my gosh, what happens when you do have that contract sitting in front of you for a potential agent or a publisher? How do you navigate? What are some of the things that you should be watching out for and aware of? So that's what we're going to talk about today. So I'll go around really quick and introduce each of you and give you a chance to really discuss yourselves and what you've got going on and tell us a little bit more about each of you. Paul S. Levine, who has been in the business for 40 years, he tells me. Paul, do you want to say hi and tell everybody about yourself?
Good morning or good day, everyone. My name is Paul Levine. I'm both a literary agent and entertainment and publishing lawyer. I've been involved in the book business, as Desireé just said, for 40 years. I'm class of 81 from USC Law School. I'm now a professor there, by the way, an adjunct professor teaching entertainment law in practice. I got involved in the book business right from graduating from law school because the very first law firm that I worked for had a couple of big clients who kind of shaped the rest of my career. The first was a publisher called Price Stern Sloan. Roger Price created Mad Libs. Everybody has played with Mad Libs. Leonard Stern, for those of you who are old enough to remember TV shows like The Honeymooners and Get Smart, Leonard Stern created both of those shows. And Larry Sloan invented bookstores in airports. In the 1970s, you could only buy a newspaper or a magazine at any airport in the world. And he got frustrated when he was traveling back and forth between LA and New York and couldn't buy a book anywhere to read on the plane. So he invented what now is called Hudson Books, and which is a bookstore that's in every airport in the world. And I learned the book business from Larry. So I was very fortunate. Most entertainment lawyers here in LA either end up concentrating on movies, television, or music, or a combination of those. Very few lawyers know anything about the book publishing business, at least here in LA. And so that's been my niche all these years. The other big niche that I have is the other big client at the law firm that I first started working for was a guy named Jack Kirby, and Jack created Captain America, Spider-Man, Incredible Hulk, Fantastic Four, Black Panther, all of the Marvel characters that you have come to know and love. And so I learned the comic book business along with the book publishing business, and now the graphic novel business. So that's been my sweet spot for the past 40 years: books, comic books, and graphic novels.
A man of many talents. Now let's segue over to boss girl Raye Mitchell, a dear friend of the BookFest. Hi, you want to tell us a little bit about yourself, Raye?
Well, absolutely. And as always, I am so delighted to be a part of this fantastic growing phenom that is feeding the need for intelligent discussion about the book business and beyond. So I introduce myself as Raye Mitchell. I am a lawyer from the past, a content producer of the present. I want to say hi to Paul. We've been on a couple of panels in the past, and we're fellow Trojans. So I did my educational experience undergraduate at USC, and stayed on and earned my MBA at the Marshall School of Business. Then I catapulted into the marketing and business world, working with General Mills and General Foods and all the big name companies, where I really honed the art of storytelling as part of marketing, influence, and reputation management. Got a little bored, went back to law school at Harvard, and had a great time. Came out of Harvard and started my own law firm. And my law firm represented my passion, my purpose, and basically what I wanted to do with my time. So I had a combination of a full service firm where I worked with my advertising, entertainment clients, both sides of the deals, heavy duty litigation and intellectual property, and basically an array of things, which today I can categorize as my expertise in helping people protect, produce, and tell their stories to the masses. And that is really where I am now with my content production company. I'm a writer and I help people extract their stories and protect their rights, whether it's the technical protection of rights or whether it's the intellectual strategic, which is where I like to go. Because as we'll talk about today, the technical parts you can get from anybody USA, but it's the expertise of my fellow members on the panel that will show you it's not just the pragmatic things, it's how do you use the pragmatic things. So my current book is called Breaking the Insidious Silence. I'm working on that now, and it's about winning in the court of opinion and winning in the court of public opinion, and it's about reputations and how storytelling matters. And it's for lawyers, non-lawyers, anybody that's a creative genius that wants to influence how their story is heard. And so today, I just want to encourage anybody that is a writer, wants to be a writer, was a writer, finds writing disgusting, anywhere you are on the spectrum, you have a story that is so important that I'm hoping today we can share with you how you can protect your creative genius. Because in the end, in an industry like this, you're either prey or predator. I prefer to be an apex predator, but that's just me.
You're a very good one. Absolutely. Yeah. What's that saying? We would rather have written than writing. People don't like writing. They like having written something. That's what it reminds me of. Okay, Professor Jonathan Arnold, Esquire, Oxford educated attorney. We got lots of good schools here amongst you guys. Jonathan, you want to tell us about yourself?
Sure. And I guess since I'm the third person here, also being a practicing attorney, the most important school we have here is USC, because I did my undergraduate work there too. So you are being bombarded by the Trojan Mafia, as we like to say. I was pre-law, but a film minor. And I am, as Paul Levine mentioned, I am one of those entertainment attorneys in Hollywood. However, the unique thing that I bring is having grown up in the industry, especially motion picture production. And I do share this thing to tether from what Paul mentioned and also Raye mentioned, is my expertise actually is in story and dramatic development, relating more to screenplays and then out licensing that as well. My father was the top first assistant director in Hollywood. He directed such fabulous fare as Bloodsport and many other things. He was Francis Ford Coppola's right-hand man. It doesn't make me the end-all be-all of entertainment law, but I have a pretty good idea of how the process for it. And as the entertainment industry looks for good story ideas, they need those story ideas. My specialty is correlating what authors are doing when they want to dive into, or let's be honest, drown in media, entertainment, little less music, but to some degree music, and now a bit more podcasting, which I do as well. I'm the former research attorney and the voice of the Finn's Advanced series on torts, civil procedure and stuff. Then I do teach as well, both at Cal State Northridge, Los Angeles Valley College. But there's a lot of love in this room because we're all Trojans here, which is a good thing. So, and I'm Desireé, thank you so much for the invite, and Paul, it's glad to be speaking with you again. And Raye, I've heard of you, so it's I feel proud to be on this panel with you today too, and I think we're gonna have a good time.
Yeah, absolutely. And that wasn't planned either. I actually just realized that now, that you all had that USC connection there. That's pretty remarkable. And I think it's interesting too, you bring up podcasting. That's such a hot thing and an emerging thing going on right now. I'll just start right there, if you don't mind, Jonathan. Can you tell us a little bit about what's going on in that world legally with podcasting and maybe some of the things that you're doing there?
Well, let me start with the business aspect. Podcasting is kind of where FM radio was probably in the 50s and 60s. There are some people, the stuff is winnowed out. I mean, there are a lot of podcasts out there. There are a lot of those podcasts that have 14.5 subscribers about somebody talking about what their cat is doing this week. Sorry, just calling it like it is. But it's basically, its original name was netcasting, without getting into arguments about, what's the normative aspect of this interest. But podcasting is kind of private radio that can be very targeted for things. So podcasting is a big development. Studios and production houses and development departments are beginning to take a look at what's happening with podcasting to figure out and forgive me for using this word, it's so 1990s, what's trending right now. So I tell folks that I represent who are wannabe podcasters or actual podcasters or just beginning about what they need to do, not only to protect their rights, but also how to think about expanding that into other forms of media.
Yeah, and I want to dig into that a little bit more. And just as an example, some people may not realize this, but the example that comes to mind is Dr. Death. That started off as a true crime podcast, and then look at what happened to it.
Right.
Yeah.
And a lot of studios. I spent time working for Paramount Pictures, but a lot of studios will take a look at podcasting and they'll use it to beta test. I came up in software and actually worked in Boeing for many years, but we'll use it to beta test or road test or taste test to see what's popular. They'll take a look at the Joe Rogan Experience, for example, to see what might be very trending and how many subscribers are liking this sort of thing. They'll take a look at, there we go, the caffeine just kicked in, Whitney Cummings' podcast, which apparently has a huge subscriber base, called Good For You. I was trying to recall the name of the podcast to see what sort of things currently resonate. It is what studios like to do before with book publishing, to see what the installed base would be. That's why Warner Brothers and the feeding frenzy happened that Warner Brothers won with the J.K. Rowling, the Harry Potter series, as well as other series that were truly also big box office in the 90s and the early aughts, the early 21st century.
Yeah. Now you bring up protecting one's IP, so I'll bounce over to Boss Girl Raye Mitchell. Do you want to talk about some of your thoughts and ideas and the importance of protecting one's intellectual property?
Yes, well, and just to not insult anyone, the concept of intellectual property is an area of law that really is a bundle of things. So there's copyright, there's trademark, there's trade dress. There's just a litany of things that have all been shoved into this notion of intellectual property. It's your creative genius. It's, in some circumstances and the right circumstances, just the notion of an idea. So when you talk about, and I include even things that I'm sure my panel members would agree or hope to agree, or things like your reputation, all these things that have value both to you and, to Paul's point, your ability to monetize, scale, engage a fan, all those things are on the radar of value. So when you talk about protecting it, again, there are technical protections, but then there are common sense protections. For example, a common sense protection for your intellectual property is don't show up with the company you don't want to keep. I had a person a former client, who's running around with his book right now. And he's so elated by the book and the coverage. And I'm like, he shows up on a platform that is, what's the word, risque. I'm like, wow, either I didn't know you or you don't know where you are. So the company you keep is a part of your intellectual property protection. And you can see it play out in the news cycle. One day you're up, and the next day you've been seen with pictures of somebody who's now doing the perp walk. So you have to manage these components in a way that is fluid. There's no one stop there. I've protected my rights and you go away. So my point is intellectual property is fluid, it's critical, and it's ever changing, and it's anything you need to protect your creative genius.
Excellent points. Paul, did you have anything that you might want to add?
Yeah, I wanted to get down a little bit more into the weeds, as it were. So, as Raye just mentioned, we have a variety of different law, some federal, some state, which protect various forms of intellectual property. There's copyright, there's trademark, there's state law here in California regarding ideas and the so-called theft of ideas. So as a practical matter, to summarize what Raye was just saying, the Groucho Marx line comes to mind. You don't want to be a member of a club that wants you as a member. So be careful who you keep company with. But as a legal, or not but and as a legal matter, there are things you can do regardless of the company you keep in order to maximize the protections that the law provides when things go south. So, copyright. Copyright protects works of original authorship. And every one of those words is important. A work is something that can be perceived by the senses. It's in the fancy words of the Copyright Act are fixed in a tangible medium of expression. Something that you can see, something that you can hear, something that you can perceive with your senses. Original means that it originates with you, that you haven't copied it from something else. And original means also that you have the work that you've created has some element of originality. It is not, for example, a phone book with a list of names and phone numbers. It's a little more creative than that. And authorship means either you wrote it or you were employed to write it. If you were employed to write it, there are requirements for what's called a work for hire, which we can get into if you want to, but for our purposes, you're the author of your work. So in order to protect that work, first of all, the first question that Desireé, you sent us on, how does copywriting one's writing work? You have a copyright in your work the moment you create it. You don't have to do anything in order to own the copyright in and to, like lawyers say, in and to the work. However, if you're going to get the work out there, you're going to send your manuscript out to a potential, or book proposal out to a potential agent who hopefully will sell the work to a publisher. You're going to send the work directly to a publisher. You're going to, God forbid, self-publish the work. We'll talk about that later if you want to, etc. If you're going to get your work out there, it behooves you to register the copyright in the work the moment you start getting it out there. Because the Copyright Act provides that if you register the copyright in your work prior to the date of infringement, and you can't anticipate when you're going to get ripped off, so the best thing to do is to register it right from the get-go, spend the $55, go to the copyrightoffice.gov website and register your work for copyright. If you do that right away and you have to sue somebody for infringement, you get a lot of remedies that you would otherwise not be able to get. You get what's called statutory damages rather than actual damages. So for a beginning writer, it is almost impossible for a writer to establish how he or she has been damaged by having the work having been infringed. So instead of having to prove, because you have no track record, you can't say on my last deal I got X dollars, so on this deal I should have gotten X dollars plus 10%, or whatever the argument may be. It's really tough to make those arguments to a jury to award you X dollars. So instead, you're entitled to get what are called statutory damages, ranging from $150 for innocent infringement all the way up to $150,000 for willful, deliberate, knowing infringement. The other element, or the other incentive for registering your work for copyright prior to the date of infringement is something that's near and dear to the heart of litigators like Raye and like me. Jonathan, I don't know if you litigate or not. Near and dear to the heart of all of us litigators, which is the ability to collect attorney's fees from the other side. Because copyright infringement litigation is really, really expensive. And at the end of the day, when you file your lawsuit and you win your lawsuit, in addition to the damages, the statutory damages that you're going to be able to get awarded by the jury, you're also going to be able to collect all of the legal fees in a reasonable amount. Hopefully your lawyer hasn't overcharged you in the eyes of the judge, but all of the legal fees you will have paid your lawyer to bring the lawsuit. If you are the prevailing party, you win your lawsuit, you can get attorney's fees from the other side in addition to those damages. That may not sound like much, but it's huge. Because otherwise, in most lawsuits, each side pays their own lawyer regardless of who wins and who loses. So the Copyright Act, in order to provide incentive to register your work for copyright, gives you the incentive of being able to collect attorney's fees and statutory damages. By the way, the reason for it is that the whole purpose of the Copyright Act, the whole purpose of the Library of Congress is to be a library containing every single work of intellectual property, book, movie, television program, musical composition, song, anything you can think of, a compendium of every single thing created in the United States. So to incentivize that, they provided for these two huge benefits if you register your work for copyright. Because when you register a published work for copyright, by the way, 2 copies get sent in, 2 physical copies. When you register an unpublished work, you can send in your PDF, and that's fine. But when you register a published work, a book that has been published by Simon & Schuster, you send in 2 physical copies. One goes to the Copyright Office and one goes to the Library of Congress. And the most fun, aside from getting your first advance check or royalty check from the publisher, the most fun that an author will ever have is to fly to Washington, D.C. and go to the Library of Congress and see their book on the shelf in the Library of Congress. I promise you, that will be the biggest thrill you will ever have as a book author, especially your first book.
Yeah. And you bring up a lot of points there. Jonathan, I'll let you chime in if you have anything that you wanted to add to that. Otherwise, I do want to kind of get into some of the, you brought it up, Paul, some of the nitty-gritties of what you should be looking for when you're looking at that contract or when you're looking at that deal. But Jonathan, I'll bounce over to you.
Sure. I got a little emotional. You could probably see it in my face when Paul started talking about attorney's fees, but there's a deterrent nature to that. And I also smiled a little bit about litigation because, yeah, I don't even want to say a recovering litigator, but I do everything I can to keep my clients out of court unless it's absolutely necessary. I know we're all shaking our heads, with that one. But Paul was really emphatic, and I think it's really well taken about registering sooner rather than later. The importance of having a deposit copy when there's infringement issues. I also want to add, because I forgot to mention, one of my other areas of specialty is actually the international components of intellectual property protection. And one of the great things about registration is it triggers almost parallel registration or triggering IP rights, as Raye mentioned, that bundle of rights, or whatever it may be, in other places, which is so important now with the digital distribution of IP, of media, entertainment. you register in the United States Copyright Office, it triggers essentially a parallel registration, kind of sort of, with the European Copyright Office. It's more expansive of your rights. So I would tell all of you as a preview, if you've heard about this thing called poor person's copyright, where you mail it to yourself, but you don't know, forget it. Not only is that not allowed, judges are now prohibited, positively prohibited of even looking at that. Paul mentioned it's not hard to do. It's less than $100. Just do it. If I can quote from that little creature, the Nike commercial, just do it. It gives you so many protections. And I'll conclude by saying, once you affix your registration number to the face page of what I tell my screenwriter clients, the face page of your work, your unpublished work, it shows everybody that you're serious and you know what you're doing. And that helps promote the business development of it.
Yeah. And piggybacking off of that too, what about sending it to the WGA, the Writers Guild of America? I've heard that too.
I know Paul and I are going to probably disagree just a little bit. That's a nice to do, but what really matters, and forgive me, I do represent a lot of screenwriters, that's a custom and practice in the industry that doesn't have much import. Only do that, A, if you have time, and B, after you've registered it with the Copyright Office.
I totally agree. In fact, I will go further and say that registration with the Writers Guild does writers a disservice, because they think that by registering with the Writers Guild, that they're covered if they have to sue for copyright infringement. They are not. All the Writers Guild does is take the envelope in which your script or your manuscript or whatever it may be is enclosed. They never even open the envelope. They date stamp it so that you can prove that on that date this piece of work existed, and that's all that happens. 5 years after they date stamp it, they literally burn it. Okay? So you're paying for nothing with the Writers Guild. I love the Writers Guild for everything else they do for screenwriters and TV writers. I do not like the Writers Guild registration program.
Fair enough.
Let me, my co-panelists made some incredibly significant points. And I want to piggyback on them for two reasons. One, I just love having these conversations. It's like IP heaven on a everyday person level. So I thank you both for your ability to translate this complex legal doctrine into consumable concepts. But I also want to make a point, which is why a panel like this is important. I've been on many of them, probably not as many as my co-panels, but I've been on many. And a lot of times people overemphasize protecting my rights, my rights. I said this is an industry of prey and predators. You got to make sure that you are not stumbling on someone else's rights and you wind up that defendant hit with those attorney fee provisions. That is a huge, I talk to dozens of people a day on certain platforms. And I listened, I was like, wow, you're infringing. And they don't seem to understand that they're out there grabbing information. They worked with someone without a work for hire agreement, and they're full steam ahead with mine. And I'm like, wow, you're a defendant. And so you need to have a mindset of not only protecting your creative genius, but you also, as part of the registration and these other things, they're great defenses at the right time to show that I didn't infringe you, because here's my proof that my work pre-existed yours, or whatever the circumstances. So keep in mind, publishing is a huge industry. I had the number, it's gone right now, that is predominantly unregulated. And there are tons of people willing to take your money. The Writers Guild, the I'll teach you how to have a bestseller in 24 minutes people. All of these streams of people preying on your desire to get that book to the Library of Commerce. I'm gonna go down there and look for my book, by the way. I hadn't really thought about that. But keep in mind, you want to be flanked on all sides of the issue, not just a frontal tunnel vision.
Great point. And what should writers be aware of when looking at that contract? I hear this all the time from writers. Oh, I've got my first contract, and they'll just sign anything. They barely even read it. Any red flags, anything that they should look for when signing either with an agent or a publisher?
Well, signing with an agent is a whole set of issues that comes into play. And then signing a contract with a publisher is a whole different set of issues that come into play. Let's talk about signing a contract with a publisher. So publishers are in the business to make money. And they're in the business of not paying out or delaying the payout of money to you for as long as possible. So the contract the first draft of the contract that the publishing contracts department sends out after your agent and the acquiring editor at the publishing house have reached a deal on the basic terms. How much is the advance? When will the advance, or in how many installments will the advance be paid? How much are the royalties for hardcover? How much are the royalties for trade paperbacks? How much are the royalties for mass market paperbacks, for ebooks, for audiobooks, etc.? When the basic deal has been done between the agent and the publisher's contracts department, staffed by lawyers, will send that publishing contract to your agent. Now, this is the thing that drives me insane about the book business versus the movie and television business. Here in LA, as Jonathan well knows, agents who represent screenwriters and television writers would never presume to read any contract issued by a studio, a network, a production company, or whatever past the first page. They would read the first page to make sure their name is spelled right. They would maybe read the second paragraph to make sure that the client's name is spelled right. Probably not. They will go to the page with the money and make sure that whatever they negotiated is reflected in the contract, and they will stop reading. And they will turn to the client if they don't already know, and they will say to the client, "Who's your lawyer?" He or she will read the other 78 pages of this magnum opus that we have here to deal with. That does not happen in the book business, and it drives me crazy. Agents in New York, in LA, anywhere, think that they know how to practice law, and they do it every day with impunity because nobody stops them, unfortunately. And they will presume to read paragraphs like, if we sell the book at other than our usual and customary discount, we will cut the above reference royalty or the above applicable royalty by 1/2. An agent would have no idea what that language means in reality. What it means in reality is that when Costco, Target, and Walmart sell a copy of your book to the consumer, they don't pay the usual and customary discount that an independent bookstore pays. They pay 2 or 3% less. Typical discount for a book is 50%. If the cover price is $30, the store will send $15 to the publisher when that book is sold to the consumer. Regardless of whatever the consumer pays for the book, the publisher gets $15, 1/2 of the cover price. Costco, Target, and Walmart, because they're the big gorillas, don't pay 50%. They pay 47% or 46%. And just because they've paid 4% less, all of a sudden, not all of a sudden, because the contract says that they can cut your royalty rate in half, instead of getting $4.50 for a hardcover book, 15% of the $30 cover price, all of a sudden you're getting $2.25. Just because the publisher got, instead of getting $15, the publisher got $14.76. You're getting cut, the publisher got 24 cents less than it otherwise was supposed to get. You're getting $2.25 instead of $4.50. That's just an illustration of contractual language that agents should not be negotiating. So the very short answer to your question, Desireé, is simple. Hire a lawyer who knows the publishing world. Pay that lawyer for an hour or 2 or 3 of his or her time to review the publishing contract and advise you and your agent on changes that need to be made. Don't let your agent negotiate the fine points of the publishing contract. Let your agent stick to negotiating the deal.
Because that's skeevy. That just sounds so skeevy when stuff like that happens. And when you read that to me or said that to me, I don't know what that means. An excellent point,
exactly.
Because most people don't.
Exactly.
So when do you feel in the process, when should somebody bring in an attorney? Is it just that?
When there's a contract to review. When the publisher has issued the contract. When an agent has offered you representation and has sent you the agency agreement for you to sign. My arrangement with my clients is very simple. They can sign as many credit card slips and as many checks as they want. Anything else they sign, I look at first.
Fair enough. Jonathan.
I would. Oh, I'm sorry.
Yes, go ahead. I was just going to say
on this question about timeline. I've made my most money after people have made their biggest blunders. So I recommend that when you're serious about this, to use Jonathan's point, A, you save yourself a kitty for the professionals, and B, start scouting, vetting, and building a relationship with prospective attorneys. But the reason is that good attorneys are not necessarily going to be available when you want her. And you got this contract, you're hot to go, you're ready to go. And all you can find is the person who barely made it across the graduation stage at a school ranked 500 when they stopped ranking at 250. So build a relationship so that when you're ready for that moment, they know you, they know your style, you have an existing professional relationship, at least to start with.
And that's a person you can go to for advice. So to Jonathan and your point, Desireé, before, you've decided you want to, include a song lyric in your book. Or you want to talk about Heinz ketchup being a terrible product, tasting terrible, or whatever. And hopefully you will at least realize, maybe I should ask a lawyer whether I could do this. Having that lawyer on board and ready to advise you is a huge step in the right direction.
Yeah, and that's an excellent point, and something I wanted to bring up too is just when you're writing a book or a screenplay, those things to avoid, such as using somebody else's mark or song lyrics and things like that. And it's basically be careful. How about parody or public domain? Does anybody want to talk about how those might work and if somebody should go down that route?
I think the concept of public domain is one of the most misunderstood concepts I have heard repeatedly. Example, I'm confronted with somebody using my trademark And my graphics person says, "Hey, Ray, do you know this person over there at church beep is using your trademark?" And I was like, "Really?" So I do a friendly outreach to the person. Her response is, "Well, I got this from the public domain." I was like, "Well, just because you pulled it off of the internet doesn't mean it was yours to use." And she was emphatic that because she found it in the public domain, she believed it was hers to take. So I caution people, and this goes back to the point about having a relationship with an attorney. Understand what's in the public versus the concept of public domain, which has legal significance.
So public domain means that it's no longer protected by copyright. There are a variety of reasons why something will enter the public domain. It can enter the public domain because the term of copyright is over. The term of copyright is the life of the author plus 70 years. So works of written by Shakespeare are in the public domain because Shakespeare died a long time before, 70 years before now. A work could be in the public domain for a variety of other reasons. It can be in the public domain because, and this gets a little complicated, so bear with me, because under the old Copyright Act, a copyright had to be renewed 28 years before, after original publication. So if old Superman cartoons, I'm giving you an example of something that's in the public domain, the really old Superman cartoons where he just has a triangle on his chest as opposed to the fancy symbol, the S symbol that has been developed by DC over the years. Those old cartoons were released, I don't know the year, let's make it up and say 1940. And for whatever silly reason, or not so silly reason, the copyright wasn't renewed in 1968 when it was supposed to be renewed, 28 years after original publication. If it wasn't renewed 28 years after original publication, it's in the public domain. Lots and lots of stuff is in the public domain because of that, because under the old Copyright Act, pre-1978, things were not, copyright was not renewed 28 years after original publication. The final reason, which no longer exists, that things are in the public domain, think, for example, of the movie It's a Wonderful Life, which is shown by every television station around the country because it's free, it's in the public domain. It is in the public domain because it was released without a copyright notice. Mm-hmm. Under the old Copyright Act, at the very end of the movie, you needed to see that C in the circle with the year and the name of the studio that made the movie, or the name of the publisher that published the book, or whatever. So lots and lots of things are in the public domain because somebody forgot to put the copyright notice on the work. No longer applies. You don't have to have a copyright notice on your work anymore. But back then, that was the requirement. So there's lots of things in the public domain because the term of copyright has expired, because under the old act it wasn't timely renewed, and or because under the old act there wasn't the copyright notice.
Yeah.
Public domain, like parody, which I'll talk about in a second, is a defense to a claim for copyright infringement. You don't want to go there. You don't want to even have to defend yourself against a claim for copyright infringement. So let's talk about parody, or let's talk about fair use, which is another defense to a claim for copyright infringement. Establishing a defense after you've been sued is really expensive. As I said before, copyright litigation for both sides is ridiculously expensive. And yes, as Jonathan mentioned, prevail as a defendant you can get the attorney's fees that you've had to pay to defend yourself from the other side. But it's a long, arduous process. Better to avoid it if at all possible. An ounce of prevention is worth a pound of cure. So, unless you're really, really clear that your work is a parody, it is a satire, and everybody will know what you're satirizing, you're making fun of Tales from
Ketchup.
Lake Wobegon by Garrison Keillor show, and you do a parody of that show.
Yeah.
Unless you're really, really clear and really confident that this is a parody and that nobody is going to be able to claim copyright infringement, don't go there. Because you're going to have to defend yourself. Unless you're really, really clear that what you're taking from the owner is a fair use because you're not making money from it, it's for educational purposes, etc. You don't want to have to defend a claim of copyright infringement by arguing fair use.
Got it. All
I
right.
just want to add how important it is for the information that Paul and Jonathan and my contributions is that I write, I produce, I develop content. I have an attorney. I don't rest on my own knowledge about what I think I know. I take my every issue to an attorney, even if it turns out that I was right, what I thought I knew I was. But I want to be extra certain because I really don't want to be a defendant. And what happens in this industry is everything's quiet on the Western Front until you start to hit big.
Mhm.
And then it comes out of the woodwork. So just because you get along a certain path, you've published the book, you're making the tour, you're like, oh, and then it starts.
Yeah.
So just keep in mind, prevention is really a wonderful peace of mind.
Absolutely. Jonathan, I'll let you bounce in if you wanted to make a comment,
Sure.
and then I have a couple questions.
Sure, and I'll just tether off both of what Paul and also what Raye was mentioning to kind of sing their praises, and that's an awful professor joke, but I'll give music as an example. First of all, what Paul mentioned was really well taken, is that parody, the transformative element required, it's when you're successful parodying, it's usually where you get hit, as Raye was mentioned, when you start making the money. But this is where it's very important to consult with an attorney. I often get, and just about 20 minutes before I was this began and I hopped on the platform that we're using, I was talking to an author, probably will become a client, and she wrote a book that's filled with lyrics from the 60s, and somebody had falsely advised her, oh, as long as you don't use more than 4 lines of lyrics or be more than 8 stanzas, you're just fine. And I'm like,
Urban myths.
yes.
Yeah.
Yeah. Or if I could go a little British, oh goodness, my no, that's not going to work. I'm thinking big of Paul and Raye of it, Suits versus Comic Mix case, where it looked like it was transformation, and the Ninth Circuit said, goodness, my no, basically. An ounce of prevention is worth a pound of cure. And the example that I give, and we probably all heard of it, is Weird Al Yankovic's parodies, his song parodies. Obviously, and you could argue there's ample transformation there, but the reality is Weird Al Yankovic has an attorney. It's not me. The lighting would be better in my office if it was me, because I could afford more IKEA lamps. The one just blew out behind me. That's why it's dark. But the reality is Weird Al Yankovic, through the advice of counsel, approaches the holders of the copyrights, plural, to almost every single song he's parodied. And not only has his seeking that business cooperation helped advance it, sometimes the publishers have actually helped promote it. So one of the business realities is that his songs often occur, and this is business legal advice, at a point where the sales or run rate of a particular thing is beginning to decline, and this helps extend it. Second thing, it's often not in the market the publisher may be seeking as their primary source of revenue. And third, it comes back to what they say in Hollywood, and I'm sure the publishing industry too. The only thing worse than bad press is no press. You know, but I know there are a lot of things when I judge moot court competitions at various schools like Pepperdine. They're like, well, Weird Al Yankovic, that's clear evidence of transformation. It's fine as a parody. I'm like going, maybe, but a better business practice, like Raye was mentioning, talk to an attorney first, because most people don't reach out and call a lawyer when everything's going just great. And yeah, as Paul mentioned, have the lawyer read the contract, not the agent. So he and I could howl at the moon forever on that issue. And I suspect Raye will probably join us in that howling too.
All right, we're running up against the clock. Go ahead, Paul.
Reinforce what Jonathan said just for a second on urban myths like, oh, you know, eight bars or whatever are free to use. George Harrison was sued for 3 words and 3 notes.
Yeah.
My sweet Lord. He's so fine by the Isley brothers.
Yeah.
The Isley brothers heard My Sweet Lord and sued him and won, even though it was established that the infringement was innocent. George Harrison didn't intend to rip off the Isley brothers song He's So Fine when he wrote My Sweet Lord. It was still infringement.
Yeah.
There is no minimum that you can take from somebody else. None.
Excellent. Okay, we're running up against the clock, guys. I do have a question or two from the audience, and then I'll give you guys a moment for final thoughts briefly. One of the questions I've heard Paul speak about this before is memoirs and the legal aspects of talking about somebody else's story when writing your own memoir. Paul, do you want to tackle that one?
Thank you. So I spend a lot of my time as a lawyer vetting manuscripts, memoirs, clearing them to make sure that there's a minimal chance that a third party discussed or written about in the memoir is going to sue the author and the publisher. So I also obtain what's called errors and omissions insurance for the author and the publisher so that the publisher is comfortable publishing the manuscript. But I'm getting ahead of myself. What I'm clearing the manuscript for mainly is libel. Libel equals a false statement of fact, which tends to lower somebody's reputation. So if I say Desireé is wearing white headphones, that's a false statement of fact because she's wearing black headphones, but who cares? If I say that, forgive me, Jonathan, I'm going to use you as an example. If I write that Jonathan is a serial killer, a child molester, a bank robber, and every other crime you can possibly think of, and I can't prove that those things are true, that's libel. A false statement of fact, which lowers Jonathan's reputation in the eyes of the community. So when I vet a manuscript and I read that my ex-husband molested our daughter, I will say to the author, show me the evidence that supports this statement. If you do not have anything that can prove that this is true, it comes out of the manuscript. Simple as that. That's how vetting works.
There's also a component. I mean, we're doing broad strokes in our last few seconds. California, but other states as well. You have to be concerned about privacy rights. Did you learn some information in a privileged communication and you're violating that? So you have privacy issues, and privacy is a big concept that has components. Another thing that you want to think about is source materials. Emails written are copyrighted by the people. I mean, they're owned by the creators of the email. So you desperately want to reproduce in your memoir the email from hell.
Or TikTok or text messages or whatever.
Yeah, and you're like, you don't own that, even if it was sent to you. So you have to be mindful that just because you have it doesn't mean you can use it.
Excellent.
Absolutely.
I'm gonna steal that from you. Just
On my
because you
next
have it doesn't mean you can use it.
that goes with my just because you can doesn't mean you should.
Excellent advice.
Very
Jonathan,
good.
did you want to add
Just
something there?
quickly to tie together some of the concepts, what Paul was mentioning earlier about public domain is you need to know about those bundle of rights that Raye alluded to earlier when we began. I know I've represented filmmakers and they've said, or they've come to me when there's an issue. They're like, but the background music is a Haydn string quartet. Haydn's been dead for a long time. What's the problem? I'm like, well, no problem with the string quartet, but the performance of that string quartet was by the Vienna Philharmonic, and it was recorded 2 years ago and copyrighted by Deutsche Grammophon. Do you really want to run up against Deutsche Grammophon's attorneys here in the US? So you often have to think about, even if something arguably its source material may be in the public domain, whose expression of that idea, which is now copyrighted, whether that's in the public domain or not. And Raye, that comes back to where it was on the internet, that's the public. Wrong answer. You got to do some checking. And that's where it makes sense to at least talk to an attorney, follow this information, and an ounce of prevention is worth a pound of cure. The old saying that I adhere to is, if you think having an attorney is expensive, see how expensive it gets not having an attorney.
Absolutely. Really absolutely. It reminds me too of fairy tales. There's a certain mouse in this industry that likes to, make sure that any fairy tales that might be in the public domain are actually kind of under them.
No.
It's like, be careful. People tell me about, I've got this retelling of a fairy tale. Okay, let's be careful there. Just because it's in that public domain. And by the way, my famous line, just so you all know, is I am not an attorney. I'm a marketer. Go talk to an attorney. But okay,
and
really
on that
quick.
note, I want to emphasize the last thing I want to say. An attorney, the right attorney, the attorney who knows the area of the law and the business that you're in. You don't want to talk to your divorce attorney about book publishing. You don't want to talk to your book publishing attorney about your divorce. Find the right attorney, not just an attorney.
Excellent. One more quick question here. I think this will be a quick one. What's the typical timeline for bringing on an agent, for having an agent be able to shop one's manuscript?
Timeline?
Like, how long should you give in the contract your agent to shop your manuscript?
Until it's sold.
Forever?
I never give up unless the client wants me to give up.
Fair enough. Fair enough. Okay.
By the way, I'm an agent as well as a lawyer. So when I say I mean because I'm an agent. As an agent, I never give up unless the client wants me to give up.
Okay, fair enough. I think that's where the question was coming from. I've had this agent shopping my book for
you can terminate your contract with your agent at any time. Some contracts provide, you got to give them 30 days notice or something. Most contracts don't, but some agency contracts do. Look at your contract. If you're unhappy with your agent and it's been a reason, I mean, if you're going to give your agent 6 weeks and nothing happens, probably wait too short. But if it's been 3 or 4 years and nothing has happened and the agent has sent it out to 30 or 40 different publishers, maybe it's time to find a different agent.
Fair enough. Okay, really quick, closing thoughts. We'll start with Jonathan. Anything you want to say before we sign off?
I would just say that when in doubt, consult an attorney. Like Paul mentioned, an attorney that works in the industry in which you work. For example, if I was thrown by a client a huge 78-page magnum opus about print publication, chances are I might consult with Paul or tell that client to go talk to Paul. Probably the same way that if Raye had somebody who says, I'm interested, I just got an option deal on a screenplay, probably want to come to me if I can be so humble about that. So an attorney who has what we call subject matter expertise, or I could say a SME without stepping on a particular mouse industry's copyright, but it's all educational purposes here, right? Of course, right? So yes, talk to an attorney first, even if that's just for a 1 or 2 hour consultation to get the lay of the land. Sometimes that can save you thousands, yea, verily millions of dollars down the road.
Excellent. Boss Girl Raye, final thoughts.
My thought would be to disconnect the idea that the attorney is over here, your creative spirit is here, and your work product is over there. I would integrate a IP attorney relationship in your project development mindset, because you never know when you need that tidbit that could be the difference between being prey or being a predator.
I like that. Prey and predator. Paul, final thoughts.
Write good books.
Done. That's the most awesome final call out we have had yet. Excellent. Paul, Jonathan, Raye, thank you so much for being here on the BookFest adventure.
Oh, we got to do the fight on. We're all Trojans.
That's right. Yes.